Zahoor Ahmed Bhatt, the academic who came here and argued for a few minutes.
Yes.
Well, that's because he argued what he argued. He was suspended from the faculty. Because on 25th August, he took leave for 2 days, went back, and then he was suspended on the 25th of August. I mean, these things should not happen in our country. I'm sure the AG will look at it.
Mr. Attorney General, just see what Mr. Sibal is saying.
I have checked up, Lord.
Yes.
After having read in the newspapers,
Yes.
I did check up. And of course, Lord, the Advocate General is also here. But what is reported in the newspaper may not be the whole truth. He files petition.
It's not from the newspaper, Malaj. The order itself, 25th of August, I've got the order with me.
No, just a minute. Allow me. There are other issues. He appears in various courts. And there are other issues also. We can place it before your lordships. And
but then he should have been suspended earlier. Why might?
He gave written submissions.
Written submissions here. This is not fair. This is not the way that our democracy should function.
Mr. Attorney General, just see what has happened. Somebody who appears in this court is suspended.
Not the ground, but we'll look into it. We'll
have a look into it and just talk to the
without doubt, without any doubt.
Talk to the Lieutenant Governor and see what has happened. If there is something apart from this, that's different. But why in such close succession to his appearing before us?
Certainly, that will be.
23rd he appeared. The order refers to this. He appeared here and then next day he was suspended. Anyway, I just wanted to bring it to your lordship. I'm sure the attorney will use his good offices,
Yes.
Do something.
Officers are here, it would be taken care of. It's not concerning this. Everyone has a right to appear before your lordships. It can never be by way of a retribution. There is something else, Lord,
Mr. Solicitor, the close proximity between the arguments and the order.
The timing is definitely not proper. I bow down. I bow down. Timing is not proper. No argument on that.
Timing and reference to this aspect, if it is there in the letter. I don't know. I have not seen the letter. I do not know. But if the reference to his appearance here is there, then there is a little problem. What happens to the so much freedoms in part?
Yes, yes. Absolutely.
Yes, Mr. Solicitor.
Lord, on Friday, on Thursday, Lord, your lordships will not desired what happened to other assimilation of other states. Lord, during the weekend, Lord, we have undertaken that exercise. The documents were available in the National Archives, and the officials of the Home Ministry went in National Archives. They studied everything, and we have prepared a 2-page note for that. If your lordship allows, I can immediately share it with others. And
what you can do, it since it was in response to a question of the court, you can just ask the nodal council to make it a part of your submissions as an annexure, so it won't get misplaced.
Correct.
Make sure and circulate to the other side as well.
Right now, would your lordships like to?
Yes, we can see it right away, no problem.
It's in fact a 1-page note, not even. Rest is list of states. So we need not read the list. The figures would matter, not the names.
In the meantime, if you have it for my colleagues on the...
Lord, can I be permitted to circulate?
Yes, no difficulty. We'll see it. Because it'll take a few minutes to otherwise come on the email.
One more. One more. One, I have already said this is from National Archives, coupled with, my lord, facts stated in the white paper. I'm sorry, my lord, my lords.
Now there on all the members of the bar will also get it on your screens in front of you actually.
It is now received. It is received.
It's now on the screens for everybody, yes.
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 First is, my lord, we have said that this is combination of our research in the National Archives and white paper. Second, at the outset, it is necessary to clarify that the process of integration of princely states with dominion of India and or union of India was not a linear process. The merger agreements and instruments of accession, along with proclamations, did not operate in a step-by-step manner for every state. They represented various means of integration of princely states with the country, the signing of either of instrument of accession or revised instrument of accession or merger agreement or even a proclamation only, like Hyderabad state, is sufficient for integration with Union of India. Therefore, the list of princely states which fall under merger agreements are separate from the list of princely states which are covered with instruments of accession or revised instruments of accession. Therefore, broadly, there are two heads, princely states falling under merger agreements and princely states falling under instruments of accession followed by proclamation. Under the first head, princely states falling under merger agreements, the princely states were of two kinds. A, princely states which merge with the existing Indian provinces. They were British controlled provinces. And second, princely state which merge with states as centrally administered areas. Some of the princely states desired that we should be directly governed. Some of them were strategically so located that
they became the chief commissioners.
Chief commissioners provinces, Your Lordship, sir. The next category of princely states, this is important. Table C are the ones covered by the instrument of accession, revised instruments of accession, followed by proclamations. The distinction between the two is of terminology and not of step-by-step linear process, as a large number of states directly signed revised instrument of accession without signing the pro forma instrument of accession before that. Therefore, the same is being clubbed and expressed as table C. Princely states covered by instrument of accession or revised instrument of accession and proclamation accepting Indian Constitution. It may be noted to the limited position emanating from the National Archives and White Paper that these princely states did not sign any merger agreement. Lord, then your lordships would come to the next page. Lord, 1 to page 1 is, my lord, 1 to 32, then 33 to 65, then, my lord, 66 to 77. The lordships have, my lord? The rest is not available. Lord, please see, my lord, the states from Balasinore to Surgana were a part of one group which had a total of 144 states. They formed their own group. Therefore, my lord, they are 77 to 144. Then, my lord, total comes to 204. So, we have started with 205. It goes up to 216. Then, provincially merged Khasi states. Khasi states were essentially in the northeast, and, my lord, they are 241. Total, my lord, are 241. Then, if your lordship turns the page, this is table B. Princely states which were merged with states as centrally administered areas.